Module 7. Closing Arguments. Introduction. The defense attorney delivers a closing argument summarizing the defense's position and challenging the prosecution's case. Closing arguments, also known as closing statements, are the final arguments presented by each side's attorneys at the end of a trial. During closing arguments, the attorneys have the opportunity to summarize the evidence, highlight key points, and make persuasive arguments to the judge or jury. The goal is to leave a lasting impression and advocate for their respective positions before the case is handed over to the trier of fact, the judge or jury, for deliberation and decision. Here are some key elements and strategies involved in delivering effective closing arguments. Summarize the evidence. The attorneys should provide a concise and compelling overview of the evidence presented during the trial. This includes key witness testimonies, documents, physical evidence, and any other relevant information that supports their case. Emphasize strong points. The closing argument is the time to reinforce the strongest aspects of the defense's case and challenge the weaknesses in the prosecution's case. Attorneys should focus on the evidence and arguments that are most favorable to their client's position. Craft a clear narrative. Tell a cohesive and persuasive story that weaves together the evidence and testimonies to support the defense's theory of the case. A well-structured narrative can help the judge or jury understand the defense's perspective and remember critical points. Address inconsistencies. Use closing arguments to address any inconsistencies or contradictions in the prosecution's case and emphasize the credibility of the defense's witnesses and evidence. Burden of proof. Remind the judge or jury of the prosecution's burden of proof. The defense's closing argument should reinforce that the defendant is presumed innocent, and the prosecution must prove guilt beyond a reasonable doubt. Logic and reasoning. Use logical arguments and reasoning to challenge the prosecution's claims and present the defense's counter-arguments convincingly. Humanize the defendant. If appropriate, humanize the defendant and appeal to the judge or jury's sense of empathy and fairness. This can be especially important in cases involving sympathetic circumstances. Rebut prosecution's closing argument. If the prosecution delivers a closing argument before the defense attorney should be prepared to rebut any new points or misrepresentations made by the prosecution during their closing. Limit emotional appeals. While some emotional appeal can be effective, closing arguments should primarily rely on sound legal reasoning and evidence. Overly emotional appeals may be viewed as manipulative and could backfire. Stay within scope. The closing argument should be based on the evidence presented during the trial and should not introduce new evidence or legal theories. Use visual aids. If allowed, visuals such as charts, diagrams, or photographs can be effective in illustrating complex information and reinforcing key points. Confident delivery. The defense attorney should deliver the closing argument with confidence, maintaining composure and professionalism throughout. Closing arguments provide the last opportunity for the defense to influence the judge or jury's decision. Effective closing arguments can be instrumental in swaying the trier of fact to rule in favor of the defense and result in a favorable outcome for the defendant.